All right, welcome to unCOMPlex number 7. We're here in July 2024. I'm working on what's coming up in days and weeks to come. So, what's on the agenda of things that we should let folks know about? We have got an amazing assortment of programs that our mediators and judges are participating in, presenting for at the WCI conference, August 17 through 21. All of our presentations are on 18, 19, and 20. Most important of all of those is the judge and mediator meet and greet, which will be on Sunday, August 18th at 5 o'clock. And that's going to be in a group of rooms, but just remember Boston. Um, and we will be there with bells on and hoping to meet folks from the general public and to talk with you about how we're doing, getting to know you face to face, and perhaps having a chance to spend some time discussing how you might think we could do things better or differently. Um, so that's going to be intriguing. I need to turn off that screen share. I apologize. There we are. All right. So the programs that we're going to be participating on, Adam Ross is presenting twice. He's going to be doing negotiation techniques as observed by mediators, do's and don'ts. That's at 2 o'clock on Sunday afternoon. He presents again 10 o'clock on Monday morning with best practices for attorneys and claims professionals in mediation. Those two rooms should be absolutely packed, and he's part of a panel on both of those presentations. But those are two topics that we really do struggle with on a day-to-day basis. We'd love to see you present. Also on Sunday at 10 o'clock, Judge Greg Johnson is going to be presenting on reporting self-determination constraints. They're working with MEAC Opinion 2023-04, and joining him will be Jeffrey Breslow. And that's going to be a absolutely essential function as we talk about what we do when people get involved in mediation that perhaps are struggling with those self-determination objectives and constraints. Also presenting are Kate Marshman. She's doing two programs both on Sunday at 1 o'clock and 4 o'clock. One has to do with the latest AI changes. I think that's going to start to impact mediation. It's certainly going to impact the practice of law. And then there's the 4 o'clock presentations on bonding with the participants, and that is establishing rapport and building foundations for moving forward. On Sunday at 10 o'clock, Mike Ember from West Palm Beach is going to be also on that same panel reporting self-determination. Let's see, Mr. Blatt is also on that program. So those got spread out in my schedule somehow. On Tuesday, we've got multiple programs running, August 20, that is, and those are going to be presented by Ileana Forte, who's doing an ethics program for judges, Judge Kerr, who's working on a presentation regarding statutory employment, subcontractors, independent contractors. And boy, if you don't understand how all that works, you're just getting to the point where you can't practice workers' compensation law. It seems to be cropping up more and more, at least in the allegation stage, whether it's in fact or in allegation. The point is we still have to deal with it. And then Judges Anderson and Pitts at 10:15 on Tuesday will be addressing the attorney's fees, motion practice, and ethical pleadings. So all in all there, we've got about 20 presentations that involve, or 20 of our individuals that are making presentations. We're really proud that on Tuesday, we're going to launch our OJCC Scholar Program. At the WCI, we'll be putting that on, and that's by invitation only, of course. But we've got some great participants. I've had various individuals ask, how do you get involved in the Scholars Program? And that's a fantastic question. All of the participants that were invited to attend and participate over the next 9 months were nominated by the judges. What we did is put out a public notification that we were doing this program, and we encouraged folks, if they were interested, to contact judges that they knew and express that interest and talk about why, when, and how they might want to be involved. The good news is that we're not going to just do this 1 year, we don't think. So we anticipate running this into the future. And so if you're just now hearing about it, understand it is a deep dive into workers' compensation. We're going to be working on the history of workers' compensation, various perspectives on the concept of the social safety net. Boy, we've got just an absolutely fantastic group of speakers who are coming in on a monthly basis by Zoom to talk about these topics, things like personalities, dealing with dynamics in a room. We've got 2 psychologists that are going to speak to us. We've got a law school professor. It is going to be an absolutely phenomenal program that's going to try to leave behind, if you will, some residue or some terminal moraine of all of the knowledge that many of us have garnered over decades in the workers' compensation system, and we're going to try to impart some of that to what I like to call the next generation. Time and again, we've talked about the donut hole, and where we have a lot of very old people in the workers' comp practice, me, and a lot of very young people, and unfortunately not a lot in the middle, although we're coming to find there are a great many of those that are in the middle that are really fantastic practitioners and bring a lot to the table. The idea here is that we're going to try to instill some of that long, hard-earned knowledge in some of those folks before we get out of here and ride off into the sunset. Also, on October 18th, we're putting on our Academy program. Registration for that is open. Email me, david.langham@doa.state.fl.us if you're interested. We'd like people with 1 to 3 years of experience for that. That is free of charge. It's going to be open to about the first 30 to 40 people that sign up. We did 40 last year. Pretty cramped in the Orlando comp office with 40 people. So we're going to try to keep it to 30, maybe a few more, but we're really looking forward to meeting the next of the best of the brightest as they come into this practice. And we're trying to give them a head start into what it takes to practice workers' comp, particularly into what it takes to try a case. So all of that's on the horizon. Busy couple of months coming up, and we're really looking forward to that. Things that I think I should talk about today. I get questions from time to time about the rules process. How does the rules process work in an administrative law capacity or system? You'll run into a lot of folks who will tell you that it runs under the Administrative Procedures Act, the APA. That's true. Some of those same people will tell you that the APA was enacted in 1974. That's not true. The APA was enacted in Florida literally almost a decade before that. And we had an APA, but we did not have a Division of Administrative Hearings. We did not have some of the constraints and protocols and processes that you would call administrative law in our modern era. Those did come in the 1974 amendments, but the fact is we had an APA more than 50 years ago. How does the rules process work? It's important for you as practitioners or as members of the workers' comp community to understand that it used to be, since 1973, that the Florida Supreme Court adopted rules of procedure in workers' comp. They did that under their, shall we call, assumption that people like me were quasi-judicial. The literal translation of quasi is almost. So when we say I'm quasi-judicial, that means I'm almost a judge. I don't know that I like that, but a lot of people probably wouldn't argue with you. Anyway, the bottom line is that if you want to make rule recommendations in the process, you used to contact the Rules Committee that the Supreme Court appointed, and then they would make proposals to the Supreme Court for adoption of rules, just like they do in civil and criminal and family. Today, the way that works is the Florida Bar has a Rules Advisory Committee. The chair of that is Neil Ambikar. And so if you have ideas for the rules, I would encourage you to reach out to Neil, Mr. Ambikar, or Mr. Eric Christensen down in Sarasota. He's the vice chair. and talk to them about what you'd like the rules to look like or do differently. The Rules Committee puts together proposals from time to time. If you're in Florida Workers Advocates, they also have a Rules Committee. And if you prefer, you can contact anybody on the Workers' Comp section executive committee, and they can help you with their sort of internal rules recommendation committee. And you can talk to them about how you'd like things to be different. The second thing on my list of topics today that I think is very important is this storm that just hit Texas. If you're not following the hurricane season, we've got the prediction out there that the warm water out in the Atlantic and the Gulf is going to mean an active hurricane season. They are now predicting, the big time experts at these universities are now predicting something like 25 storms, half of which are going to be hurricanes, and 6 of which they think will exceed Category 3 status. I don't know why they draw a line at Category 3. At the end of the day, if you've lived through a Category 1, that's pretty much exciting enough for anybody, or at least exciting enough for me. I would encourage you to think through today, while the map on the NOAA site is showing calm waters out there, to think about what you would do in the event that a hurricane threatens. Too often, we always believe that nothing bad's going to ever happen. I'm not going to be in a car accident while I put on my seatbelt. I'm not going to this. I'm not going to that. I remember back in the day, Hurricane Floyd came knocking on my door when I was in Jacksonville. And I literally spent a day packing up my law office in the back end of a minivan and a truck. And I headed west with all of those papers and files and computers with every expectation that I was going to be down and out of business for a while. As luck would have it, the storm turned. I wasn't knocked out. I spent another day putting my law firm back together. But today, in our digital era, with what we've got on the internet, with what you've got on disk, you really ought to be able to back your practice up on a simple flash drive or an external hard drive. And you ought to be able to be fairly comfortable driving away from a premises somewhere and taking your law practice with you in your back pocket, your purse, your backpack, wherever you might put it. So I would recommend that you think about how you're going to retrieve and save your data. I would recommend that you think about where you're going to go if a storm hits. From where you are, do you run south, north? Do you run inland? You've got to think these things through ahead of time and have a plan. As part of that plan, I would encourage you to communicate with others at your office about where they're going to go, or at least how you might get a hold of them or get a hold of people that they would contact. I know nobody likes to give out their mother's phone number, but if that's who you're going to tell that you're safe, that's a pretty good idea for your coworkers or at least your partners in your business or managers in your business to know that that's who they could contact to make sure that you're safe and that you don't have needs that are unmet. The time for that is now. I would also pay attention, if you would, to what they call the Waffle House Index. You can find that on various blogs, but it turns out that the folks at Homeland Security pay a little bit of attention to what Waffle House is doing. And that's because when Waffle House shuts down and sends their employees home, it means they believe something pretty serious is about to happen. So you can sort of follow that Waffle House Index. Honestly, folks, you might ride out a hurricane, a Category 1 hurricane. I've ridden out Category 3 hurricanes. I don't ever want to do it again. So I would caution you against that and encourage you that you might want to sort of pay attention to the season and have your plan in place. Be ready to throw that flash drive in a pocket and get away from the landfall of the storm. What's coming in terms of changes at the OJCC? It seems like something's always changing. We have done some programming lately. Back in the spring, some folks got a little perturbed about some of the changes we made, but I think that's settled down and people are getting attuned to it. We work on the way the program functions on an almost consistent, persistent basis. I say almost because we share our programming team with the folks at the Division of Administrative Hearings. And so there are times when those those folks are engaged in working on what the ALJs do and how their cases function. And then we get their attention back to us and we work on changes that can facilitate you doing your job. We are persistently finding things that we could do better. A lot of that comes from your questions and suggestions. So I encourage you to reach out to us. My email address is all over the internet, but it's david.langham@doah.state.fl.us. And if you've got an idea for how EJCC could function more fully, more effectively, more efficiently, I'd love to hear from you. And then we can talk with our programming team about what can be done and when things can be done. Perhaps a change can come from your idea or suggestion. The big change that is coming sooner rather than later, you all remember that in 2020, we shifted to telephonic mediation. Boy, that was just a huge shock that came with the pandemic. Telephonic worked, and it worked reasonably well. I don't want to belittle it in any way, but at the end of the day, what we found was that we think that video works better. So as we came out of the pandemic in the 2022 timeframe, we switched to predominantly Zoom for mediation. Because of that, the mediators being virtual, remote, if you will, we had to come up with a way for lawyers and parties to sign those documents. And you're familiar with the program we went with, which is sort of like DocuSign, called Sign Easy. And it made it possible for the mediators to shift documents and get those reports in. It's really important those reports get in. I just throw in as a side note, way too many lawyers are not signing the document and returning it. Now, that's not out of some malevolence, okay? What they're doing is they reach a resolution at that mediation, and they're putting together a notice of resolution and filing it with the judge to say, hey, that hearing and that pretrial can come off. We've resolved the case. But the problem with that is the mediator is still sitting out there in left field, and he or she's waiting to get that mediation report back so that she can change the characterization in our database to be able to say that that she did or didn't resolve the case. Impasse, all issues resolved, all but fees. That kind of detail we need to collect and report to the legislature. It's hard for us to collect that data if you don't sign the report and return it. So I would appreciate it if you could put that in your focus and start to think about that. It's going to be easier to sign. We're coming into that. What we've done is we've shifted from the Sign Easy to Adobe Acrobat Pro. And so what you're going to start seeing in weeks and months to come is the mediators at the conclusion of the process transmitting documents to you using the Adobe process instead of Sign Easy. What's the point? Well, one point is narrowing the amount of bandwidth that we're using up in terms of our brains. So if we're already using Adobe Acrobat for a series of processes and procedures, and it can accomplish the signing task, well, then we get rid of Sign Easy, and that's one less thing we have to remember how to do and remain proficient at. So that's an efficiency element. A second idea or concept is the cost element. We're already paying for the Adobe Pro with your money, right? All of the support for the OJCC comes from the premiums collected for workers' comp insurance. We don't spend a penny of tax dollars, but it's still your money. And if we're already paying for the Adobe program and it can do this function, then why don't we get rid of the program we're paying extra for, the Sign Easy, and be a bit more efficient while just as effective? So those are the two big drivers as to why we're going to make this change. How is this going to impact you as a practitioner? Frankly, it's probably not going to be a big impact or a big change once you get beyond the first few days or the first few instances of using it. I have seen it demonstrated. It seems to be very easy and simple. And so my expectation is that we're going to get used to it very quickly and get that probably in place in months and weeks to come. So what else is going on important in workers' comp other than getting those mediation reports in? We continue to see a fair number of folks who are struggling with evidentiary concepts. Boy, it's frustrating because the foundation that you need to lay to put together your process or procedure of putting documents into evidence, okay, is just not that challenging. You can literally Google how to authenticate documents through testimony, or just how to authenticate documents, and the internet will give you the 3, 4, 5, 6 questions that are probably a good idea to ask. You should be doing that before you get to trial. But if you find yourself at trial, the other side's making objections, you're not getting your document in evidence, or you're not getting your statement admitted over a hearsay objection, why not ask the judge to take 10? Judge, could we take a few minutes so that I could use the restroom and think about this objection? I don't know that every judge is going to give you that opportunity, but some probably will. And then take your smartphone, go out in the hall and Google, how do I respond to a hearsay objection? How do I respond to a authenticity objection? It's probably not the best practice, but you will learn through your mistakes. And it's a better practice than simply giving up and saying, well, Judge, I don't know how to get this in evidence, so I guess I'll quit trying, we'll move on. If that document's important to put in evidence, folks, you need to keep working at it and put it in evidence, or at least be able to look yourself in the mirror afterwards and say, I made a pretty good run at that, and I did or I didn't get done what I need to get done. Don't know. We've also had some questions recently about the motion for rehearing. Too many people don't realize that the motion for rehearing in workers' comp under our 60Q rules is somewhat different than the rule in the civil or criminal practice. So in circuit court, if you file that motion for rehearing, that may have some impacts that assist you. In workers' comp, it's not going to toll the time for filing your appeal. You still only get 30 days to file that appeal, folks. So if you file the motion for rehearing, you would like to see the judge enter an order on that pretty rapidly. If you read the rule, you'll find that if the judge doesn't rule on it pretty rapidly, that means that it's denied. Then once it's denied, then you can in good faith get on with filing your notice of appeal with the court and get on with the process of litigating your case. If you don't, boy, the 30 days is jurisdictional, folks. And that means if you don't file the notice of appeal within 30 days of the judge's final order, that the court may very likely not entertain review of your case. Now, I say may because I'm not the appellate court. That's their decision, not ours. But being late, I can tell you, just has a tendency to have the court give a lecture or description of the topic of waiver, okay? And they explain how the notice of appeal is jurisdictional. And once that jurisdictional time period of 30 days passes, boy, then they can't entertain your appeal. Another frustrating point we've run into lately on appeals that bears mentioning is the content of the record. The rule of Appellate Procedure 9.180 describes for you precisely how the record on appeal works, what the timelines are, and how you can pursue and prosecute an appeal. I would caution you, if you don't want to read those rules, you should probably get some help from somebody that has. The appellate process and practice is anything but easy. It is complex in its own ways. It has its own intricacies, and it's challenging. So what you really need to think about and be aware of. Number one, you're supposed to file the filing fee when you file the appeal. And there's instructions on our website on how you can do that. You can do it electronically. You can mail that check in to the First District Court of Appeal, or you can seek a determination that the fee should be waived, or that it should be paid by the Division of Workers' Compensation. We get too often that motion for waiver or for relief in tandem with a motion for relief of the cost of preparing the record. Those two shouldn't come together because you don't know how much the record's going to cost yet. How can you file a motion and an affidavit that says you can't afford the record when nobody's told you what the price is yet? So address your filing fee first. Get your notice of appeal filed, and then our office is going to issue you a notice of the estimated cost of the record. And it's at that point that you can look at that and say, well, here's the amount of money it's going to cost for this record. I can pay it or I can't. And if you can't, you're going to move for an order of indigency. Well, then that's the time to file that. Get it in front of the judge and get the judge to make a determination. Again, this is all in the rules, and it's somewhat intricate and complex. You want to work through it carefully. We also had a recent incident where some of the documents that were filed with our office were difficult to read, difficult to see. You know that when you file and upload these records. So when you're filing records with the judge's office as evidence for your upcoming trial or as support for your upcoming motion or the motion itself, it's your obligation, it's in your best interest to make sure that that document is dark enough in terms of the text, is clear enough in terms of the character and quality that the judge can read it and appreciate what it says and what it might or might not mean. It's your job to present the competent evidence. And so if you're uploading documents that are blurred, that are too light to read, okay, that are obscured in some way, you are tying one hand behind your back. Now, hopefully the other side of the case is going to make an objection based on that. And they're going to say, well, we shouldn't proceed, Judge, with this particular copy. We'd like for you to order them to produce a legible copy. But boy, if nobody notices that, you can literally get down to the time of the judge entering the final order or even the record on appeal before somebody figures out, hey, this copy of that particular medical record is difficult or impossible to read. How can you fix that? If you discovered at trial, immediately after trial, okay, you should probably file a motion, okay, a motion to amend the record or a motion to substitute a legible copy. This is the sort of thing that lawyers probably should most of the time, 99.9% of the time, agree on. Cases are supposed to be decided on their merits. And so if your opposing counsel has made an error and uploaded an illegible document, and they call you and say, I'd like to substitute this legible copy, the answer should probably always be yes. Now, if you've got serious or significant doubts about authenticity or hearsay, objections you would have raised if you could have read the original filed document, then raise those. But if it's just a matter of the document that ended up on our docket is too light or too smeared or blurred, then you've seen the original and the other side's seen the original. You can probably stipulate to that or make an agreed motion and the judge clears it up before he or she even gets the order out. If you see the record get prepared, there's absolutely nothing wrong with noting in the record that there's something like that, a mistake, an error, a difficult to read. Then you move to amend the record. Once the record is certified, that you need to take up with the appellate court. But know that the appellate court might very well grant your motion to substitute a document. If they do, they're likely to tell us to prepare a supplemental record. Well, we can't do that if you haven't filed that legible copy with us. So just keep in mind logistically that we all need to be on the same, I hate that, page. But we do. We need to be on the same page. So if you've got a page that's not readable and you're going to send a new page to anybody, you might think about sending that new page to us at the same time so that we can facilitate and help you through that process. All right. What are we seeing in terms of where the practice is going? I'll tell you something that disappoints me. We every year are seeing a decrease. I know, not monumental decrease, but we're seeing a decrease in the interest in board certification. What does being a board certified lawyer say about you? I would suggest that it supports that you're committed to this practice, I would suggest that it supports or at least suggests that you know what you're doing and that you've been involved and engaged in this practice long enough to achieve that accolade. I would suggest that it's a nice demonstration of your commitment and your involvement in who we are and what we do. If you go on the Rules Advisory Committee page of the Florida Bar that I mentioned at the opening, you'll find the pictures of the chair, Mr. Ambikar, and the vice chair, Mr. Christensen, and you'll notice right there out to the right of their names that they're both board certified in workers' compensation. That means something, folks. Um, I have lawyers sometimes ask me, is it worth it? Well, okay, worth what? Are you going to make an extra dollar an hour because you're board certified? I don't know. Are you going to attract clients because you're board certified? I don't know. But I can tell you that if you're board certified, that's going to demonstrate to people around you that you know what you're talking about and that you have achieved a status that is noteworthy and praiseworthy. Is it difficult to get? I would suggest to you that there is some serious work involved. You've got to amass that number of trials. You've got to pass the examination and the documentation. The documentation is probably the biggest headache. I hadn't been practicing 6 months when I tried my first workers' compensation trial. I don't remember now what it was, but it was exceedingly minuscule in terms of the amount of benefits I was defending. I got the distinct impression that my client and my law partner had conspired to send me to the comp office to try that case just so that I would have the experience of trying the case. As I recall, I lost pretty miserably. When I got back to the office and I was working on what the judge had assigned us, back then judges often told us to prepare proposed orders. And I was back tinkering with that. That partner dropped by my office and she brought me a board certification application form. And she said, turn to page, whatever it was, 7. And she says, put this trial on that form. And I looked at it. It required, I believe, 30 trials at the time. I looked at it and I said, well, why do I want to spend my time on this? And she said that she had been practicing for 20 years at that point. I had thought about being board certified and wasn't doing it because she didn't want to take the time to go back and remember all those 30 trials and who the lawyers were and who the judge was and what the outcome was, etc. And so she said, if you just do that as you go, as a young lawyer, she says, by the time you get 3 years into the practice, 4 years into the practice, you'll have all that listed out, and doing the application for board certification won't be nearly the chore that it is if you just sit back after 30 trials and go back and try to remember who those counsel were and judges, et cetera, et cetera. So I would strongly encourage you, if you've got any interest in being part of this practice, to dig into that application, do it early, keep up with it on a week-to-week or month-to-month basis, keep it current, and when the time comes, you'll be ready. And I also encourage you to get involved in things like the section if you're going to try to become board certified, because that group that runs the workers' comp section is full of board certified lawyers who can provide you all kinds of guidance, advice, and assistance. If I can help you with your board certification application or with any questions about that process, you're more than welcome to email me. I can't talk with you about cases, that's ex parte, but I can talk to you about things like board certification. I'm happy to do so. I'll be at the WCI for 3 days this August, and if you catch me in the hall and want to talk about board certification or anything else, by all means, feel free to reach out. Next on my list of interesting items, ex parte communication is challenging to us in almost every regard. You cannot communicate directly with the judge that's assigned to your case. Now, you would think that that's a conversation that we would have most of the time with pro se litigants, whether they're employers or employees. But time and again, we're having that conversation with lawyers. They feel that there's an informality. They find that there's a familiarity, and they think, well, gosh, I should just feel free to reach out and email Judge Langham or Judge whoever. Boy, if you're going to send an email to a judge, you need to copy the other parties in the case. And if you're not going to reference the case and make it some broad question, you know, can a fella this or can a lady that? Don't be surprised if you don't get a response from the judge. And if you do get a response from the judge, and then you cite that response later in any kind of a pleading, you're going to have put yourself and the judge both in precarious situations. And that's why most of the time, general horseback, things like that, you're not going to get a response. If you do get a response, it's liable to be a quotation out of a rule or just a copy of an entire rule, with the suggestion being, hey, read this, might help you. Time and again, we get those communications. Too often, we're getting phone calls to our district offices where the inquiry is, hey, we got the order from Judge so-and-so. What do we do next? That's not a question for our staff. That's not a question for the judge or the mediator. What you do next, that's up to you. If you can't answer that question, you need to do some research. If you can't find the answer to the question doing some research, you probably ought to reach out to a mentor. Wow, okay, you don't have a mentor? Look up the list of lawyers that are on the Executive Council of the Workers' Compensation section. I know every one of those people. Many of them are absolutely nothing short of brilliant. All of them, in my experience, are nothing short of gracious and helpful. And if you call them and say, "I've got a problem and I need some advice," I would almost bet you my lunch money that they're going to call you back and they'll be willing to either tell you some good things or some bad things, or they may refer you to somebody else and get you some help out there. That's where you go for advice and mentoring. That's where you gain the sort of community experience. Asking the judge what to do next is just simply not the right path forward. It creates both real problems. A lot of lawyers don't know this, but the rules of professional responsibility say you will not engage in ex parte communication. Engaging in ex parte communication violates the rules you're sworn to uphold as a lawyer. Even fewer lawyers know or remember that the Code of Judicial Conduct says that I will not encourage or allow ex parte communication either. And so that means when you send that email message about a case to me and you don't copy the other side, you're creating a problem for both of us. And at best, you're creating an appearance of impropriety. How do you feel if you walk into a hearing or tune in on Zoom to a hearing and the first words out of your opponent's mouth are, Judge, this is the motion we filed because your deputy clerk told us to. Or, Judge, this will probably solve the problem with such and such, and your deputy clerk thought this motion would be the best way to fix this. You're going to feel wronged. You're going to feel inappropriately treated, and you're going to feel like the judge has done something untoward. And if the staff actually did give you that advice, you're going to be right. It's not appropriate. It's not the way we should be practicing law. So we take ex parte and we just mark it off our list. It's just not something we do. It's not that hard to carbon copy your opposing counsel. It's not that hard to file a motion. Time and again, folks can't seem to remember that in this system, any request for relief, that is anything you want to see happen, can be raised by motion, 60Q 6.115. File a motion. Pick up the phone and call opposing counsel. Talk about the motion. Talk about the problem you're having. Oh, she's a pain in my neck. That's fine. Lawyers can do that. You got to remember the lawyer's job is to get what they want. Their job is not to give you what you want. But we can disagree with each other without being disagreeable. Okay? Call them and talk to them. If they say I can't agree to that, then fine, put that in the motion. I called and talked to lawyer so-and-so. She says, he says, cannot agree to this. Then file the motion. Get the judge involved. If you need a hearing, for goodness sakes, tell you one thing I really get tired of is folks that will contact me and they'll say, I want to complain about Judge so-and-so because she or he entered an order on my motion without holding a hearing. And I pull up the motion and I say, well, you didn't ask for a hearing. Well, but I thought the judge would. No, you assumed the judge would, and you were wrong. You don't have grounds to be upset with the judge because you made an assumption that turned out to be a bad assumption. If you want a hearing, my advice is lead with that. Yeah, finish with it too, but lead your motion with comes now the, pick a party, and moves the judge of compensation claims for a hearing on this motion for the purpose of the entry of an order regarding whatever, compelling discovery, compelling protective order, compelling, man, what do people remember? I talk to non-lawyer groups a lot of the time. I try to get people to understand that if you want folks to remember something, the three C's are the most important thing you can remember, because that's what psychologists tell you you're going to remember. That's the way the brain works. The three C's are primacy, recency, and frequency. People are going to tend to remember what you told them first, what you told them last, and what you told them most often. Lead with the fact that you want a hearing. End with the fact that a hearing is necessary on this motion, right? And that way, you're building into the expectation when the judge first reads it that maybe there's more here that needs to be said or more here that needs to be examined, and maybe a hearing is the appropriate and the proper process for moving forward. Does that mean you're going to get a hearing? Absolutely not, folks. Come on, right? The judicial discretion, and it's up to the judge whether you're going to get the hearing or not. But back to that old crazy saying, if you don't ask, you're probably not going to get. So if you want a hearing, the time to ask for that is in that motion, or if you're not the moving party, in the response comes now the employee or employer responds to the motion filed by the other side, right? And requests a hearing on the motion for the following reasons. Yada, yada, objection, objection, argument, argument. And at the end, wherefore, right, my side moves for a hearing regarding the motion filed on such and such for the above stated reasons and to present argument and answer questions regarding why this order should or shouldn't, could or couldn't, does or doesn't. It's your job to communicate. A lot of people think that the job of lawyers is to be smart. Boy, I don't think that's true. Being smart is important, but that's a tool for doing the job. Being smart is not the job. The job is knowing how to do the things you need to do to try a case or to negotiate a case or to make a contract or whatever kind of law you're practicing. That's how to do, the what to do, the when to do. Okay, that's the job. And all of it has to be accompanied by not just a modicum, but a full measure of professionalism. So somebody calls you and wants your feedback on a motion, give it to them. I can't agree to that. I can't agree to that. Be upfront with them. There's absolutely no measure or purpose in jerking somebody around. Give them a phone call back. Don't have time to give them a phone call back? I'm not big on it, but reply by text. Got your voicemail message. We're not going to agree to that. Or we do agree to that. Sorry, I can't reach you back by phone. I'm in hearing. I'm in deposition. I'm in labor. I don't care where you are, right? No, if you're in labor, don't send the text back. Have somebody else do it. But at the end of the day, most of what we need to do is to work on moving our cases forward and to do it by treating others the way we would like to be treated. If we do that, the practice of law is a much more enjoyable place, much more professional place, and a much more functional place. We've come up on 3/4 of an hour. I don't have any questions in the chat box, and I appreciate the folks that tuned in. If briefly, I apologize. We had to move the time on unCOMPlex 7 today, but reminding everybody again that your opportunity to see our mediators and judges will all be posted in the announcement blog on the OJCC website. We'll have that post up this week, and so you can kind of set your schedule and come see your mediators and your judges, ask your questions, and try to develop camaraderie and experience with those around you in this practice. A lot of changes are coming in the next 10 to 15 years. I think the law in general is going to change dramatically. The practice is going to, and your profession is going to. That's going to be easier, maybe. That's going to be better, maybe. That's going to be more comfortable, probably, if you're not going at it alone. So reach out, find mentors, find peers, find camaraderie and collegiality in this community, this workers' compensation, and try to be a part of something bigger than you. And I think it'll work out better for you. Double checking the chat box and nothing up for group discussion. I thank you for tuning in for unCOMPlex 7, and we'll see you back in August for unCOMPlex 8 with our special guest, the Executive Director of the Workers' Compensation Institute, Andrew Sabalik, scheduled to join us and is going to talk about some of the experiences and education that you can anticipate coming up in August down in Orlando. So that's my pitch for today. Thanks for tuning in. Be well.